Justin, what's an example of an intellectual property issue that a lot of people just don't understand?
One of the things that comes up is intellectual property. Some types of intellectual property cross over each other. So what I mean by that is sometimes you'll have something that has both copyright and trademark as an example. So let me share my screen here if this will let me. So let's take the Starbucks logo, which most people in the United States will know. So the Starbucks logo is both a trademark, but it has copyright elements in it. When you see this on something, it shows the origin of a type of coffee. So whenever you see this, you know, oh, that coffee originates from this company, from this source. And that helps you to understand whenever you see that you're going to have a consistent quality, the same type of service, all of those elements. Now you get rights in a trademark because you can stop people from using a trademark. You can stop people from trying to confuse customers, those types of things. Those are trademark rights. On the other hand, there are elements inside of this that I'm sure are registered copyrights as well. So this mermaid, the drawing there is, for lack of a better word, it's art. And so art can be protected by copyright. The difference being that it doesn't matter if it's associated with coffee. It doesn't matter if it's associated with anything. It by itself is a protectable work through copyright. And you can stop anybody from copying your work by using copyright. And you can also register copyright through the Copyright Office. So this same design could potentially be registered at the Copyright Office and at the Trademark Office. And it gives you different rights, and it's for different public policies. And I don't know that people necessarily stop and think about this or understand it, because people use the words interchangeably.
Let me ask you a question. So, could someone use Starbucks and associate that name with another type of product?
So that's an interesting question because trademarks do follow classes of goods and services and that sort of thing. So that's why we have Delta Airlines, Delta Faucets, Delta Dental,
Mhm.
because people aren't going to be confused by those things. That being said, sometimes you have more famous marks that the more famous your mark is, the more protection you have and the more ability you have to stop people. It is possible that somebody could, um, well, Starbucks would certainly fight them, but it is possible that the word Starbucks or something like it could be used in a different field, say like I don't know, construction equipment or something completely different, where somebody wouldn't think it's related, and there wouldn't be any likelihood of confusion. So you just have to. It's tricky with famous marks though to be able to do this because if you were to take McDonald's and put it almost anywhere, that mark is so famous that it becomes difficult. But it doesn't help you with these copyright elements. Like you cannot use the copyright elements in any other context because it's a different standard. The different standard there is whether you've copied those things, not whether it's going to confuse a customer.
You're talking about the mermaid.
Yeah, the mermaid herself, and potentially the overall medallion here, but the word Starbucks coffee wouldn't be protectable by copyright, only by trademark. So you have these overlaps, but using them together, you can stop all sorts of different activities that one or the other might not be able to stop. So it is an interesting thing that's not well understood.